Swayam Prabha. Digital India. Educated India.
Well, students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU. Today I am going to discuss punishment and human rights. This is my 13th lecture and which is related to human rights and punishment. So, in this lecture I will try to understand the theory of punishment and how the manner of punishment may affect the human rights of the accused also, human rights of the offender also. So, punishment and human rights are directly connected with each other. We will try to understand that how punishment is interlinked with human rights, what are the various theories of punishment where and what are their views about punishment, and punishment may be cruel, punishment may be inhuman, and manner of execution of death penalty may also be painful. So, all these things will be taken up in this lecture and all these things will be discussed in this lecture in the light of judicial pronouncement. We will try to understand right to life, protection against inhuman treatment, protection against cruel punishment, that is human right, as you all might be knowing. So, let us start this talk with the help of international instrument. You all might be aware about Article 5 of the international instrument. When I use this word frequently, you might have seen that I use, you might be knowing, you might be aware, assuming that you all are law graduate or pursuing your graduation, it would be very beneficial because human right nowadays, the scope of human right has got new recognition in legal fraternity, and you might be aware that many international organizations as well as national organizations working for cause of human being. So, many petitions are filed pro bono, you see pro bono cases are filed in Supreme Court and High Court by highlighting the plight of poor people who are unable to fight their case. So, that is why I have decided and I have chosen this topic. So, you see this Article 5 of UDHR, Universal Declaration of Human Rights 1948, Article 5 talks about right against inhuman treatment, protection against cruel punishment, Article 5. So, Article 5 of UDHR says that no person shall be punished without law, no person shall be subjected to torture or inhuman treatment. It would be violation of their fundamental right, their human rights, and all the member states of UNO who have put their signature and member states which are signatory member of that Universal Declaration of Human Rights, those states are bound to have this kind of provision in their legal system. So, we too have, India too has adopted that declaration, India is signatory member of that declaration. So, we all have adopted this provision in our legal system, in our constitutional scheme, protection against cruel punishment. As you all might be knowing that there is a basic rule that no punishment without law. If law was not in existence at the time of commission of the act, that act cannot be covered in penal statute, which was not offence on the date of commission of the act. So, this is the basic law of criminal jurisprudence, that no person shall be punished for that act which was not offence on the date of commission of the act. So, that is a kind of protection available in Article 20, Clause 1, ex post facto law, no punishment without law. The second important thing is that rule of proportionality, that person must be punished for that act which was offence on the date of commission. According to rule of proportionality, an accused must be awarded punishment in that proportion which he has breached the law. So, the quantum of punishment must always be in proportion to the act, to the wrong committed by him. It not be greater penalty is also prohibited. So, according to rule of proportionality, the accused must be awarded punishment according to the act committed by. So, rule of proportionality also plays important role. Now, come to another aspect of this right, punishment without law, right to life as human right. As you all are aware about this precious right to life as a human right, Article 21, right to life as a fundamental right. Just I want to refer Article 21 of the Indian Constitution. No person shall be deprived of his life or personal liberty except procedure established by law. Meaning thereby, a person can be deprived from his life or personal liberty with procedure established by law. Murderer has no right to live in this country. A person who has killed somebody, a person who has committed murder has no right to live in this holy world. He might be awarded either death sentence in case of arrest of rare brutal killing, or he may be awarded life imprisonment. So, Article 21 gives liberty to enjoy that right to that innocent person, to law abiding person. Law abiding person and innocent persons, they can fully enjoy this precious right to life or personal liberty, but a person who himself is a lawbreaker, who himself has breached the law, cannot claim this protection from the state. So, that is where you see, you might have seen that many times Supreme Court has said that death penalty is a codified murder. I will discuss all these things in coming session. So, Article 21, right to life as a fundamental right, and procedure established by law, death penalty. Section 53 is very relevant, and it would be pertinent to mention Section 53 of the Indian Penal Code. Section 53 IPC talks about 5 kinds of punishment. As you all might be aware about Section 53 of the Indian Penal Code, according to Section 53, there are 5 kinds of punishment: death sentence, life imprisonment, simple or rigorous, fine, and forfeiture of property. These are 5 types of punishment. So, problem is not with forfeiture of property or fine, the problem is with death penalty or life imprisonment. So, it has been matter of debate among different humanitarian organizations that what should be the mode of execution of death sentence, whether the mode of execution of death sentence should be hanging a person with rope, which we have adopted under Section 354, Clause 3 of the CRPC. So, many humanitarian organization has raised the objection that that is very painful. Beheading is also a mode of execution of death penalty. In Gulf countries, death sentence is executed by stoning, by public. So, these are the various method of execution of death penalty, death sentence, and we will have to see which is more, which is less painful and should be allowed. So, constitutionality, even you see the constitutionality of Section 354 CRPC was in question. The manner of execution of death sentence is very painful. Once the person is hanged with the rope and he is hanged till the death, so that is very painful. We will discuss all these things. Let us understand this types of punishment, Section 53, Article 21. 21 and 53 you will see, then punishment and human right, we will understand this. in the light of this doctrine of arrest of error. With the help of this slide, I would like to explain you the doctrine of arrest of error, and because before, you see, prior to this judicial pronouncement, the law was not clear on death sentence or life imprisonment. You see, the case is Bachchan Singh versus State of Punjab, AIR 1980 Supreme Court. In this case, Supreme Court for the first time evolved the doctrine of arrest of rare case. Life imprisonment is a rule and death sentence is an exception. This is the gist of, in nutshell, you can understand the ratio decidendi of the Supreme Court. The ratio decidendi of this case is death sentence should be awarded in rarest of rare case, life imprisonment should be a rule, and death sentence should be an exception. So, what would be the case of rarest of rare, where trial court should award death penalty, death sentence to the accused? So, Supreme Court has, you see, Supreme Court for the first time evolved this doctrine of rarest of rare in Bachchan Singh case, just to provide a mirror to the subordinate court, so that subordinate trial court, while awarding death sentence, they can see that case in that mirror, mirror of rarest of rare, so that they cannot commit any error, any mistake while awarding death sentence or life imprisonment. So, the mirror of rarest of rare has been helpful to the subordinate, to the trial court, while deciding death penalty or life imprisonment. Trial courts, particularly session courts, are at liberty to apply their mind discretion. Either they can award death penalty or life imprisonment in case of murder, because section 302 talks about punishment for murder, and in section 302 IPC it is specifically mentioned that court may award death sentence or life imprisonment and fine both in case of murder. So, court has been given discretion, and that discretion, you see, that discretion is subject to this doctrine evolved by Supreme Court, subject to rarest of rare case. If murder comes within purview of rarest of rare case, only then session court may award death sentence to the accused. Otherwise, death sentence cannot be awarded, life imprisonment will be given to the accused. So, session court, indirectly we can say that the discretion of session court is subject to this doctrine of rarest of rare. So, now that ambiguity has been removed by Supreme Court after evolving this concept rarest of rare. So, now we will try to understand that what case would be the case of rarest of rare. You see, for example, Supreme Court, you just look at your screen. You head of state is killed, where head of country, head of state is killed, prime minister is killed. In prime minister, Rajiv Gandhi, you see, Rajiv Gandhi assassination case, Indira Gandhi assassination case can be put in this category, rarest of rare case, where prime minister of a country was killed by terrorist. Rajiv Gandhi assassination case, Indira Gandhi assassination case, General Vaid assassination case, murder of former Chief Minister Beant Singh, Punjab Chief Minister of Punjab Beant Singh. So, we can put all these murder cases in this category, rarest of rare. Manner of commission of murder, brutality of murder, magnitude of murder, magnitude of this crime, where members of entire family or community are killed, all these may be covered in rarest of rare category, and trial court will not hesitate to award death sentence. Session court will have no hesitation in awarding death sentence to that offender who has committed this kind of brutal murder or this kind of act. So, this thing is very clear in your mind, then when doctrine of arrest or error would be. Now, you see another aspect of human right and punishment is, which you can refer, where Supreme Court has intervened in this matter. With the light of these two important judicial pronouncements, you can justify your argument that Supreme Court has given guideline or Supreme Court has lay down criteria that mental agony or mental trauma of accused who has been prosecuted and convicted for committing murder may also be taken into account while executing that accused offender for death sentence. So, undue delay in execution of death penalty may be a bona fide ground to condone the death sentence of the accused where authority has failed to execute him, to execute death sentence to the offender, and there is no sufficient reason for unreasonable delay. There is no cogent reason for undue delay. So, undue delay may be taken into account and death sentence may be condoned, and that person, you see that accused who has been awarded death sentence, death penalty is not executed, undue delay is caused to that offender. So, it would be violation of Article 21 of the Indian Constitution, which Supreme Court has held in this case. You just look on your screen, TV Vathishwaran versus State of Tamil Nadu, AIR 1983. Delay in execution of death sentence is violation of Article 21. So, you see how delay in execution in death penalty may also be connected with cruel punishment or human rights of the accused or offender. So, you will have to consider this case. Supreme Court in TV Vathishwaran case, I have highlighted these two cases, you just look at this. TV Vathishwaran versus State of Tamil Nadu, AIR 1983. In this case, Supreme Court held that where death sentence is not executed in a specified time, it would be violation of Article 21 of the Indian Constitution. Death sentence may be converted into life imprisonment where undue delay is caused. You need to understand that undue delay in execution of death penalty may be a ground for conversion of death sentence into life imprisonment. So, what Supreme Court observed in this case, Supreme Court held that where an offender is awarded death sentence, from that date, on the date of award of death sentence, not only the accused, not only the offender who has been awarded death sentence dies, but his entire family, which is entire family, all the members of his family who are directly associated with him, they also suffer from mental agony, mental trauma till the execution of death sentence. So, not only accused, not only offender who has been awarded death sentence dies per day because he has to apprehension in his mind that tomorrow or day after tomorrow he would be hanged. So, having all these things, all these relevant considerations in mind, Supreme Court held that undue delay in execution of death sentence would be a ground for conversion of death sentence into life imprisonment. So, Supreme Court will not hesitate to convert death sentence into life imprisonment. In this case, death sentence was converted into life imprisonment. So, you need to understand that how that aspect of how Supreme Court adopted humanitarian approach in this case, how Supreme Court took the advantage of humanitarian laws, human right issues connected with this case, and on that basis Supreme Court said that death sentence may be converted into life imprisonment where undue delay is caused by the jail authorities or by the authorities in executing death sentence. Now I will try to explain you second important case, that is Triveni Bain versus State of Gujarat, AIR 1989 Supreme Court. In Triveni Bain, what happened? Triveni Bain versus State of Gujarat, AIR 1989 Supreme Court. Again, the appellant Triveni Bain pleaded that Honorable Supreme Court had passed a judgment earlier and Supreme Court has already held that delay in execution of death sentence would be a ground for conversion of death sentence into life imprisonment. In the same case, in Triveni Bain case, the facts are similar and that is why the accused was also entitled to get the benefit of TB Bhatteswaran case and his death sentence should be converted into life imprisonment. Supreme Court didn't accept the plea of petitioner on the ground that it cannot be claimed as a matter of right. It depends upon the discretion of the court. Supreme Court may convert death sentence into life imprisonment after considering all the relevant factors. So Supreme Court rejected the application of Triveni Bain on the ground that it cannot be claimed as a matter of right. This is not the right of the accused, which accused can claim. It is the discretion of the court. If courts finds that there is undue delay in execution of death sentence, then death penalty may be converted into life imprisonment. So this is all about this delay in execution of death sentence may be violation of fundamental right to life, how this right to life is connected with that aspect, delay in execution. Now, as you might be knowing that there are two important theories of punishment. With the help of this slide, I will try to explain you a reformative theory of punishment and retributive theory of punishment. With the help of this slide, I will try to explain you whether death penalty should be retained or death penalty should be abolished. It has been matter of debate whether death penalty should be retained or should be abolished. So retention or abolition of death sentence is directly concerned with human right. So there are two important ideology, there are two important schools which I would like to refer. Reformative theory of punishment is in favor of abolition of death sentence, and retributive theory of punishment, it is based on retention of death sentence. As you all might be aware about the basis of the approach of retributive theory of punishment, that is tit for tat, eye for eye, no leniency to the offender. This is the gist of this theory. Retributive theory, exponent scholar of this theory, they argue that offenders, they do not deserve any kind of leniency. They must be hanged in case of murder. They tit for tat, sathe satyam samacharet. This is the ideology of retributive theory. This is the ideology sathe satyam samacharet, dusht ke saath dusht ka vyavhar. This is the spirit of retributive theory. So the whole philosophy of retributive theory is based on tit for tat, eye for eye. Offender must be punished for their act, for their wrong deeds. On the other hand, a reformative theory of punishment, they argue that a scholar of reformative theory of school, they argue that offenders must be given an opportunity to repent. Offender must be given opportunity so that they can repent themselves, because there is always possibility to repent for the act which a person has committed earlier. Why? Reformative theory of punishment believes in rehabilitation of accused. Accused offenders must be rehabilitated. They must be brought into the mainstream of the society. one chance, an opportunity, so that they can be brought into the mainstream of the society. Punishment is not a remedy, but in the light of these two contradictory approaches, we will have to see which school is right or which school is. I don't want to go in that technicality, which school, which ideology is good or bad, but on the basis of judicial pronouncement, you can justify your argument that what is the role of Supreme Court, what Supreme Court thinks about whether Supreme Court in favor of retributive or reformative theory. I just want to mention one name, otherwise this lecture would be incomplete without referring the name of that great scholar, great judge of Supreme Court, Justice Krishna Iyer. You all might be knowing about Justice Krishna Iyer. He is considered as father of reformative theory of punishment in India. Justice V.R. Krishna Iyer has observed that we should believe in bail not jail, bail is a rule and jail is an exception. He also observed that Justice V.R. Krishna Iyer, he said that I believe, he has observed in a case that he believes in a Valmiki operation. Valmiki, as you all might be knowing, that Valmiki, he wrote a great epic, Ramayana. So he said that, Justice V.R. Krishna Iyer observed that, I believe in Valmiki operation. Every saint had his past and every sinner has his own future. On the basis of this observation, you can say that even he was in favor of rehabilitation. On the other hand, retributive theory, a scholar of retributive theory, they argue that offender must be punished. Rehabilitation is not a method. They should teach a lesson so that they cannot repeat the same offense in future. So this is the retributive theory and retention. And so in the light of these two contradictory views, we will have to understand the punishment and human rights, how these two things are connected. Now look at this, constitutionality of manner of execution of death sentence. This slide makes it clear that the constitutionality of manner of execution of death sentence, the manner in which death sentence is executed in India, particularly in India, and you may have idea about section 354(5). I have referred this section 354. Procedure regarding execution of death penalty is very painful. You all must remember this case, Dina versus Union of India, AIR 1983, Supreme Court. This is the first case wherein the constitutionality of manner of execution of death sentence was challenged by the petitioner. That section 354(3) talks about manner of execution of death sentence. A person who has committed murder is awarded death sentence. That death sentence must be executed with rope till the death. He should be hanged with rope till death. So that is very painful. So on that basis, the constitutionality of, and it is violation of, it was pleaded on behalf of Dina, counsel of Dina before Supreme Court, that it is very painful. The procedure prescribed in section 354(3) is very painful. So it should be struck down because it is very painful and it is violation of Article 21 of the Indian Constitution. It is also violation of Article 5 of UDHR, which talks about protection against cruel punishment. So even offender deserves a peaceful death, a right to die. So Article 21 is also 21 and Article 5, which talks about right against cruel punishment. But Supreme Court, after having expert opinion in this case, medical expert, and Supreme Court held that this is less painful. Execution of death sentence, procedure regarding execution of death sentence in India is very less painful in comparison to that procedure which is adopted in China, in Gulf or in other countries. That is very less painful. So, that is not violation of fundamental right, neither violation of Article 5 of UDHR. So, in this way the constitutionality of section 354 was upheld by Supreme Court in this case, Dina case. So, many times this question is asked in your PCS examination, judicial PCSJ examinations, in which of the following case Supreme Court for the first time held that section 354 CRPC is constitutional, or in which of the following case the constitutionality of manner of execution of death sentence was challenged. So, there may be 4 options, there may be 4 cases, and Dina versus Union of India may be one option. So, you all need to remember this case. This is a very leading case on this point. Another important case on this point is Jagmohan Singh versus State of UP. This case was decided by 5 judges bench, held that death penalty is constitutional and is not violation of Article 14, 19 and 21. You see, again in this case the constitutionality of death sentence was challenged by Jagmohan, and this case was decided by 5 judges bench of the Supreme Court and upheld the constitutionality of section 302 IPC. You may be aware about section 303 IPC. In Mithu Singh versus State of Punjab, Supreme Court for the first time declared section 303 IPC. I just want to write this section 303 IPC unconstitutional in Mithu Singh case, Mithu versus State of Punjab. So, you just can refer this case also. So, because discussion section Supreme Court held that in section 302 IPC, trial courts, particularly session courts, have 2 options, either they can award death sentence or life imprisonment. So, if case does not fall within category of arrest of arrear, then life imprisonment should be awarded. If case falls within ambit of purview of arrest of arrear, then death sentence should be awarded. So, there is no doubt at all. So, Supreme Court said that this thing Article 302 is constitutional, it is not violation of 21 and 14. Now, you see the most significant provision and the most important thing on which human rights organizations they raise objection about capital punishment and human rights issues. So, you see in Bachchan Singh case, as I have already highlighted in my previous talk, that in Bachchan Singh versus State of Punjab, you just look at your screen, AIR 1980, Supreme Court evolved the doctrine of arrest of arrear. Article 7 of ICCPR 19, no one shall be subjected to torture or cruel or inhuman punishment. Article 7 and Article 5 of UDHR. Article 5 UDHR. So, I just want to, and Rajan second is Rajan Prasad versus State of UP, 5 judges 4-1 held 302 IPC is not violation of Article 21. So, I just want to explain these 2 cases. You just in Bachchan Singh case, Supreme Court evolved doctrine of arrest of arrear case. Article 5 UDHR and Article 7 of ICCPR, International Covenant on Civil and Political Right. International Covenant on Civil and Political, ICCPR. So ICCPR versus UDHR. So Article 7 talks about right against cruel punishment. If I ask you that which one is more important, International Covenant on Civil and Political Right is important or UDHR is important? So many times students are confused in giving answer, in giving reply to this question. You see, Article 7 of ICCPR also talks about right against cruel punishment. Article 5 of UDHR also talks about right against cruel punishment. So which one is more important? So the answer would be ICCPR is more important because that is covenant and ICCPR is a declaration. Though declaration is binding, but ICCPR being a multilateral agreement, so being a multilateral agreement, the content of that agreement, covenant, is binding on all the member states who have put their signature, who have given their consent, who are the party to this international. So that is why this covenant is more important. So I have given this additional information to you. This covenant is important because of agreement, because of its nature. It is of agreement. That is agreement. This is declaration. UDHR is declaration. So you need to remember all these things. In Rajan Prasad versus State of UP, this case was decided by 5 judges bench. You see, Supreme Court has been emphasizing that Section 302 is not constitutional. Section 302 IPC that which talks about punishment for murder, death penalty, either death penalty may be given or life imprisonment may be given. So there are two options available to the court, and on the basis of doctrine of rarest of rare, sentence may be awarded. It doesn't violate right to life or personal liberty because it is specifically provided in Article 21 of the Indian Constitution. A person shall be deprived from his life or personal liberty with procedure established by law. Who has breached the law, who has violated the law. So criminals, they cannot enjoy personal liberty. Their personal liberty can be curtailed. Article 21 itself talks about this, under what circumstances personal liberty can be curtailed. Even right to life can, murderer has no right to live in this holy world because it is specifically mentioned in Article 21. So you will have to read Article 21 in the light of 302, and whenever you refer 302, you must understand this Section 302, it gives liberty to the state to take the life of that offender who has committed murder in a brutal way. So with this, I would like to quote NCRB report on murder. Now we will try to see how NCRB report is helpful in deciding this. NCRB report, you all might be aware about NCRB, National Crime Record Bureau. This NCRB report on murder, as per NCRB report on murder, death sentence as a deterrent, for example, Bombay bomb blast. Why I am talking this? I am talking about retention and abolition of death sentence. So country like India, can you imagine that death penalty should be abolished? No, not at all. Even I am not in favor of abolition of death penalty. The reason behind this is that death sentence create apprehension, deterrence in the mind of the offender, habitual offender, whose profession is to commit murder. So the offender who are professional killer, they must be awarded death sentence. The only remedy for those offenders who are indulged in killing, who are professional killer, they must be awarded death sentence. So, I am in favor of retention of death sentence, and many of you maybe agree with my view, and you must understand that retention of death sentence may mitigate, may be a good solution for this country. So, that is why I support this death sentence must be retained. Why this death sentence must be retained? I just want to refer few important incident which happened in India. Bombay bomb blast case, you might be aware about this case. Parliament attack, terrorists who were involved in this Indian parliament attack, Nirbhaya incident. Why I have chosen these issues? Just to explain you, just to give you example that in such a situation the retention of death penalties should be our paramount concern, and that is why we have not abolished this punishment as of now and should not be and must not be. You see, this Nirbhaya incident also compelled the government to rethink that capital punishment, death sentence must be awarded in such kind of offences. Nirbhaya incident. Indian legal system has adopted reformative approach, reformation, rehabilitation of offender, arrest of rare rule. So, in the light of these, how we can establish harmony in this? You all might be aware about such kind of incident, parliament attack, Taj hotel attack in Bombay, Azmal Kashab. So, can you imagine that incident which took place in Bombay, in Maharashtra, where Ajmal Kashab committed that crime. So, can you imagine that death sentence should not be awarded to that kind of offender? That must be. So, we have a good legislation, we have effective legislation, and recently Parliament has enacted a new criminal law on this, Bharati Nyaya Sanhita BNAS. So, IPC has been repealed. So, right now we have new legislation on this, and we hope that we have also, Indian Parliament has also inserted new crime in this, and there are severe punishment for few offences. So, you all must consider all these things. Apart from this, you see how punishment and human rights, when we talk about punishment and human rights, this topic would be incomplete without referring these incidents: Parliament attack, Nirbhaya incident, Bombay bomb blast, Godhra incident. The lecture would be incomplete. And it is pertinent to mention two important case laws. So, I would like to mention in this case. The first case is State of UP versus M.K. Anthony, AIR 1983 Supreme Court. State of UP versus M.K. Anthony, AIR 1983 Supreme Court. This is a leading case, and when you will go through the facts of this case, you will be surprised to know, and then you will find that the doctrine of rarest of rare. In this case, in State of UP versus M.K. Anthony, M.K. Anthony, he was prosecuted for committing murder of his ailing wife, sick wife, and two children. And you see that he himself had confessed his guilt, that he killed his wife and two children because he was a poor. I am referring the facts of State of UP versus M.K. Anthony, AIR 19. So, I just want to refer this case, just mention this case on your screen. State of UP versus M.K. Anthony, AIR 1983. 3 Supreme Court. So, you see what happened in this case. M.K. Anthony had killed his wife and 2 children due to poverty. He was very poor. He was not in position to provide medical assistance to his wife, ailing wife, and he confessed his guilt before the authority, before the court, that when he killed his wife, he thought that he would be unable to feed their child, he would be unable to provide food to his 2 children. So, in that apprehension, he also killed his 2 children. And he informed the police. Police arrested him. He confessed his guilt before the court. He said that he had no hesitation in this, and he killed his wife and 2 children due to this reason, because of poverty. Can you imagine that this case should be considered as a rarest of rare, and by considering this case as a rarest of rare, M.K. Anthony should be awarded death penalty, death sentence. If Supreme Court would not have evolved doctrine of rarest of rare, then can you imagine that session court, on the ground of quantum of magnitude of crime, because he had killed 3 persons, 2 children and his wife, so obviously 3. So, session court, district trial court would have this doctrine of rarest of rare plays important role, and it gives opportunity to the session court to consider the case, to put that case in rarest of rare case, in exceptional case, or so considering this case, M.K. Anthony case, trial court convicted him for committing murder of 3 persons, wife and 2 children, and awarded life imprisonment, not death sentence, because he committed that crime due to poverty. He was unable to provide food to his children and medical assistance. He had no money. He had no means to provide food or medical assistance to his wife. This case was not considered as fit case for arrest of rare case, and he was awarded life imprisonment, not death sentence. And you see, in this case, state government had made appeal that sentence was not adequate. So, Supreme Court also awarded life imprisonment in this case, considering that case not as a rarest of rare case, because Supreme Court said that court, while awarding death sentence, must consider all the relevant factors, and rarest of rare doctrine has already been evolved by Supreme Court. The second important case which you can also refer in this, that is Rameshwar Prasad vs. State of UP. Rameshwar Prasad vs. State of UP, where Justice V.R. Krishnaiyer has made a remark about criminal. So, in Rameshwar Prasad vs. State of UP, AIR 1979 Supreme Court, Justice V.R. Krishnaiyer said that, I believe in Valmiki operation, every saint had passed and every sinner has his future. So, Valmiki, he was a great saint and he wrote Ramayana. If Valmiki had written that kind of epic, so if person would be provided good atmosphere, so even sinner may have his future. So, this concept, this observation is based on reformative theory. So, V.R. Krishnaiyer, as I told you, that V.R. Krishnaiyer was in favor of rehabilitation of offender, because it provides opportunity to the offender to bring them back in mainstream of the society. So, rehabilitation process may play important role in protection of human rights of the offenders. So, we will have to look towards these two important ideology, deterrent theory of punishment and reformative theory of punishment. So, which one is more important, it all depends upon, and Supreme Court has made it clear that by applying rarest of rare doctrine, trial court should award punishment, life imprisonment should be given, or death penalty depends upon the heinous of crime, magnitude of crime, and in this way we can justify our argument that how punishment and human rights are directly interlinked. As I told you that section 354 CRPC, which talks about manner of execution of death sentence, has been challenged, the constitutionality of that provision has been challenged in Supreme Court, and Supreme Court also upheld the constitutionality of that provision. Manner of execution of death sentence is less painful, and the system which this country is having right now, that is good in comparison to other countries. So, ICCPR, in the light of that international instrument ICCPR and UDHR 1948, we will have to consider the relevancy of punishment. Article 5 talks about cruel right against cruel punishment, Article 7 of ICCPR and Article 21 of the Indian Constitution. Role of Supreme Court in recognizing rights of offenders, and Supreme Court, particularly Supreme Court has evolved the doctrine of rarest of rare case. So, how this rarest of rare case, you see this doctrine has been helpful in protection of human rights of the offender also. So, can you imagine that this doctrine of rarest of can also be referred as an effective method, as an effective tool through which Supreme Court has been able, has played important role in protection of human rights of the offenders. So, otherwise they would have been awarded death penalty even in case of murder, but Supreme Court evolved this doctrine just to impose a check and balance. So, in order to create check and balance upon subordinate court, so that they cannot misuse their discretion provided by section 302 of the IPC, Supreme Court evolved the doctrine of rarest of rare. You can also refer this doctrine of rarest of rare has been effective in preventing, or you can say it has been effective in protection of human rights of offenders, even convicts who are convicted by the trial court or high courts. So, many offenders who are first degree offender, they have committed murder due to not due to lust or vengeance, or they are not professional killer and they have committed murder, they are first degree offender. There is any family dispute or due to, or in order to save their societal image, their father, they have committed their murder. They have committed murder not due to lust or getting money or extortion money. So, in that case life imprisonment should be a rule. So, by awarding life imprisonment to such kind of to the offenders who are a first degree offender, we have been able to protect their rights, and it also gives opportunity to those offenders to repent themselves, and after repenting, when they repent their past deeds, wrong deeds, they can also bring back in mainstream of the society. So, I have referred each and every aspect of punishment and human rights. I also try to make relation, I also try to put connection between rights, between punishment and human rights by referring Article 5 of UDHR, Article 7 of ICCPR, Article 21 of the Indian Constitution, and Bachchan Singh vs. State of Punjab, Rameshwar Prasad vs. State of UP, Jagmohan vs. State of UP, and State of UP vs. M.K. Anthony. So, all these things would be very helpful for you to understand the concept of punishment and human right. I do believe that all you have understood the things which I have just discussed in this lecture. With this, I would like to conclude my lecture and thank you all.
Hello, I am Shikha Dikshit. I teach psychology and I work with the Department of Humanities and Social Sciences at IIT Kanpur. Today I will talk about what is causal attribution or how do people understand causes of behavior. Causal attribution is one of the major topics in social cognition in psychology, and this refers to the fact that people attribute causes to their own behavior as well as to behaviors of others. So, understanding the antecedent conditions of behaviors and events is one of the major topics in social cognition. Causal attribution is about finding explanations, and these explanations serve a functional purpose since they are useful in the purpose of planning of behavior and regulation of responses. As far as attribution of causes is concerned, generally people either do internal attribution or external attribution. Internal attribution when causes are understood in terms of internal characteristics of people, and external attribution when causes are understood in terms of contextual and situational features. The main perspective that is employed in the understanding of causal attribution is the naive scientist perspective, and this has emerged from the research on attribution itself, and it views attribution process as a detailed and systematic causal search. And this is the dominant view about understanding attribution in social cognition. However, in recent time this is not the only view. There are alternative views also which try to understand how people make quick judgments about causality. So, now the question is that why is it that people make causal attributions? The answer to this question can be provided in terms of need for prediction and control. People need to predict their environment, and hence it is important for them to understand antecedent conditions of any behavior or any event. Also, causal analysis is related to various other processes other than attribution. It also becomes the basis of regulation of responses. People also develop causal theories based on their experience, and they employ these theories in different domains. As far as attribution theory is concerned, it consists of mainly three theoretical formulations. One is the Heeder's theory of naive psychology, the other one is Jones and Davis's correspondent inference theory, and the third one is Kelly's covariation model and causal schemas. There are other areas of psychology also from where some principles have been picked up and extended to understanding of causality. These areas are emotions, self-perception as well as personality. Psychologists have also tried to understand attribution in specific domain areas. Psychologists have tried to outline the different dimensions that people use to understand causality in domains such as achievement domain, that is understanding causality regarding achievement related behavior such as success and failure, depression, helping behavior as well as close relationships.